Newsfile is brought to you in association with MTN.
Everywhere you go.
Bank of Africa, as strong as a group, as close as a partner.
Where Duraplas goes, water flows.
Star Assurance, your solid partner.
Ghana's most useful app. Hubtel is everything you.
Visit the St. Thomas Eye Hospital and get advice on which treatment works best for you.
Fernart Ghana. Think wood. Think Fernart.
News analysis platform. And here on Newsfile, as always, we put Ghana first. The Office of Special Prosecutor and its Galamsey corruption investigations. The NDC is demanding the arrest of Gabia Sarotredako and others who were named in the Professor Frimpong Boateng report, revealing the rot that happened during the period when they were trying to fight Galamsey. Is this the usual politics or fair game? The police have shot, they have killed persons they say are land guards. Land guard activity is criminal. So why are we unhappy about what has happened? Parliament has set up an inquiry into the shooting at Botiano. To what end? When will the police shoot crime instead of the suspects? How do they manage that delicate balance to protect us, at the same time not killing suspects, especially those they claim fire at them first? Today, we'll make time to interrogate the take or pay energy contracts that have brought a mounting debt situation, and it is feared to trigger doomsday. The majority in Parliament has been holding press conference to make their claims known that the NDC just messed us, and that's the reason the economy is suffering. Fact or fiction? I'm Samson Ladia Nyanini. We'll be right back to deal with the vexed matters.
Supply.
Seni besini fayya, seni yara, seni besini fayya, besini fayya, abray besini fayya, seni besini fayya,
Welcome back, and here is Samson's take. I titled it, How to Stop Galamsey, the Doma Way. You could say the Berbiara Neha Way. Illegal mining, or Galamsey, and its devastation can be stopped. The president, with all the awesome powers of the state, has lost the fight. Fact. The patriot, an accomplished surgeon, first to perform open heart surgery in the country, Professor Kwabena Frimpong Boateng, is battling costly defamation suits for fighting Galamsey, or trying to fight it. In fact, he may face prosecution for corruption in relation to how his dissolved committee handled money and seized excavators, machines, vehicles, and gold nuggets. The office of Special Prosecutor may also not win an aspect of the fight, or easily, for obvious reasons. A soldier has been killed in the pursuit. State officials paid to regulate mining are compromised. Security officers sent to check Galamsey end up offering protection or joining politicians, politically exposed persons, and chiefs who are neck deep in the illegal business. The business that is damaging our forest, destroying our farms, and cocoa as well, poisoning our water and threatening our very existence. Yet it is only a small group of lawless, wicked, and greedy people who are involved in destroying the population and posterity. Journalists and citizens who dare to blow the whistle on their crimes are endangered. And the media, their media organizations, have to pay legal fees fighting nuisance suits, also known as SLAP, strategic lawsuits against public participation. They sue so that you don't get to comment about the issues. But Galamsey can be stopped. It has been stopped in the Bono region. Brekung, German North, German South, Drobo, Doma, just to help you locate the people who make us feel really proud. I'm talking more especially about the true, bold, and wise people of the communities in Japekrom, in Winem, Asiri, Berbianeha, and Adomesu. They have been united and victorious in the fight to the extent the Operation Vanguard Task Force never saw the need to visit those areas. Unfortunately, they even stopped licensed mining activities there because they know too well that much Galamsey happens on so-called legal concessions. Led by their chiefs and queen mothers and working with assemblymen, the locals have frustrated and prevented Symphony Limited, a registered large-scale mining company, from doing any work there since 2011. Not even showing proof of valid prospecting licenses granted by the company in 2016 got them to operate on any of their 5 concessions in these districts. The company had to write complaining and seeking state intervention and protection to work. It informed authorities about how community leaders, especially particular assemblymen, mobilized the people against their operations. They feared they would lose their livelihood, their farms, their cashew and cocoa farms. They used community radio and also went round announcing over loudspeakers the dangers of Galamsey and why it was important to do everything, even if it meant bloodshed, to protect their lands from officials who sat in Accra and gave out concessions when they did not own any piece of land there. A chief who tried to convince the people to support the company got destooled. Yes. Things escalated forcing a curfew, which was renewed in October 2019. They never changed their position, despite letters from the Minerals Commission confirming the company had valid permits. Well, they needed more than that. A registrar of the Lands Court in Tema, Sebastian Agbo, was recently dismissed for fraudulently preparing as many as 30 court orders. This was made public a day after the Supreme Court, speaking through Justice Jones Doche, in a unanimous judgment, indicted him, Sebastian, and Justice Emmanuel Ankama over suspected tampering and manipulation of court documents to give a decision which the 5-member panel quashed. The court also fingered lawyer Maurice Ampao for undervaluing properties of a dead wealthy Reverend Minister, Emmanuel Dogbaji, to cheat the state in the amount of tax to pay. The court referred all of them to the Chief Justice for further investigations of what it described as, quote, a sordid affair and shameful conduct, end quote, that cast a slur on the integrity of the judiciary. A careful study of the judgment seems to indicate proper investigations may show an aspect of the findings of the court is faulty. But let those who must face prosecution be charged and not merely dismissed. That's not how to fight corruption in the state. The state can show a far superior example in the Galamsey fight. But we, the people, make the state and donate power to politicians to act for our welfare. Let communities emulate the people of Doma or Bebianeha to unite against Galamsey, and we shall succeed. And that is my take. We'll be right back to canvass the matters that we have put together to discuss this morning.
We believe that if government wants to demonstrate seriousness in the fight against Galamsey, it must go beyond the arrest of Professor Frimpong Boateng. It should go wider by ensuring the arrest of government and Jubilee appointees at the heart of government, which includes Mr. Gabi Ochiredako, the president's cousin, the Director of Operations, Mr. Lord Comey, including Honorable Joseph Albert Kwam, who have all been cited by the committee. It is our opinion that a public inquiry on the committee reports and damage to our forest reserves is necessary, especially with the now wider destruction of our lands and rivers by Galamsey operators. It is unthinkable that the state, including all its reserves, its lands, rivers, money, people, are left to an elected government to manage. And it turns out that the government itself is a key sponsor of the destruction and misuse of these resources. In addition to calling on the government to institute a public inquiry, we wish to also team up with the eco-conscious citizens of Ghana. Number one, we ask government to revoke the executive instrument EI 144, forest cessation forest reserves. The instrument is 2022. The EI in operation will remove 361.50 acres of forest from Achimota forest reserves, and that's the lungs of Accra.
Right, so the speaker you just saw and heard, Dr. Rashid Pelpuo, MP for Wa Central, Ranking Member, Lands and Forestry Committee of Parliament, and he's also the president of the African Parliamentarians Forum on Population and Development. He's right here in the studio. Good morning and thank you very much for joining us.
Thank you. Good morning.
Great. Also joining us, Samuel Atachia, MP, Abuakwa South Constituency and Chairman, Mines and Energy Committee of Parliament. We'll also be joined by Bobby Banson. He's a lawyer and an author as well. He's the author of this book in my hand, Civil Litigation in the High Court of Ghana by Bobby Banson. Will help us to appreciate some of the laws as far as these matters are concerned. Thank you so very much, Samuel Atachia, for making time to join us also.
Pleasure as always.
Great, great, great. So, you say that the special prosecutor should arrest the people who were named in Professor Frimpong Boateng's report to the president, which got leaked recently. Is it the normal politics, usual politics that you are on, or what?
Well, definitely no. We are very much convinced that the state, the special prosecutor, is aware of the dangers we are facing today, the extent to which Ghana is put in a situation of destruction over years of Galamsey and cooperation by government itself. And if the report is anything of significance, it has led to the arrest of the chairman, the former chairman of the committee on, interministerial Committee on Mines and Illegal Mining. And if that significance is placed on Frimpong Boateng to the extent that he is questioned and even arrested, it shows that there is something significant in the report. And the most significant thing is that names of government officials are mentioned, and these names have been seen to be part and parcel of the destructive activities that are going on. So nobody had thought about the arrest of Frimpong Boateng over destruction, over what do you call them, over the machinery, the excavators that, those are just, by the way, how do we get this man quiet? Is the reason they got him. But essentially, they are targeting him because of the report. And the report is touching directly on the nerve of government. And so for...
It's not just excavators that the OSP is looking at.
But...
It talks about other machines, talks about vehicles.
Yes.
It talks about even money that was made available to the committee and how it was spent.
Yes.
It talks about gold nuggets.
Yes.
The task force, as it went round, seized gold, among other things. How have they been accounted for?
Yes.
So the special prosecutor's interest is on corruption and corruption-related offenses in respect of the activities of the dissolved committee.
But what we are saying is this, that this is all triggered by a report done by the committee, chaired by Professor Frimpong Boateng. And we are interested in all of that because the people we are dealing with, the MPP we are dealing with, cannot be trusted in all these matters. In fact, it's an indication of how far destructive they have gone. They have taken the excavators, they have corrupted the system, they have taken gold nuggets, they have done everything that is unthinkable by state officials.
If it is not for the populist political purpose, tell us what it is. When the special prosecutor informs the world on the 10th of October 2022 that it was investigating this committee in respect of the issues we have mentioned. And then once Professor Frimpong Boateng's report gets leaked, they issue a statement again because civil society is calling on them to take the report and take action. And they issue a report to remind us on the 3rd of May this year that they are still on their investigations they began in 2022, and that tens have been invited have been arrested, so to speak. And as you know, there's one individual from the Jubilee House formerly who is fighting to be investigated, to prevent the SP from investigating him.
Yes.
So if you are aware of all of these, and we are told that, but for Professor Frimpong Boateng situation getting leaked by whoever, we would not have known that they have been investigating many people. How do you come to hold a press conference to say, arrest ABC?
Samson, it's very simple. These you have elaborated are key and necessary actions that are taken. And we think that by spelling them out and by taking that action isn't much our problem than the fact that the people who had been given the mandate to run this country are mentioned to be key individuals who are involved in all the destruction we are seeing. And we are very much interested in the state itself, the managers of the state itself. I mean, the managers of the states themselves to be accountable for what has happened or what is continuing to happen. And so we believe that by extending that arrest, we would have been confident that government is serious and is doing the right thing. And that's why we are asking for it.
The special prosecutor tells you,
yes,
that I have been investigating these people and that no single person connected to these activities will be spared.
Yes.
That they are investigating hundreds.
Yes.
And they have already spoken to or interrogated tens.
Yes.
All of them, no one has gone on self-recognizance bail, meaning they were arrested. No one went without a caution statement.
So we are happy.
Yeah, so why the press conference?
The press conference
all of these?
The press conference is 100% necessary. But we are not against the fact that the state, the investigations are going on. That's not our concern. I mean, we are not against it. We want more investigations to go on. We want more arrests to happen. We want further input into it by subjecting it to public investigation. That's what we are looking for. And so don't appear as if by that press conference we are against the arrest or the significant legal body that is doing what they are doing. We are happy that they are doing all that, but we are calling for further action, and that's very key to us. Arresting Frimpong Boateng alone is not satisfying.
You are back to that.
Yes.
You don't believe the special prosecutor when it tells you, Office of Special Prosecutor, when it tells you that there are many people involved.
Yes.
Not only Professor Frimpong Boateng,
yes,
but for Professor Frimpong Boateng's, intervention, interaction, encounter being leaked.
Yeah.
You would not have known that many people have been there. And of course, you know of one person from the Jubilee House also who was also named and who has been fighting the special prosecutor from arresting him. So what is the need? What was the need for your press conference?
The need is to create this kind of consciousness we are talking today. Create a situation where Ghanaians are aware that there's a rot happening, state involvement is there, the special prosecutor is working on it, but has not gone far enough. We are calling on him to go further than what he has done.
How do you know that it has not gone far enough when you don't know the specific persons in the tents that have already been interrogated?
The question is, why would he not let us know? And so we have to question it. I mean, you don't do these things as sacrosanct, as if it is a secret. We want everything to be clear. And if it is not clear, we call for it to be clear. It's necessary, and we will do more. We want to assure Ghanaians that nothing should be hidden from the ears and eyes of Ghanaians.
You didn't say
yes,
that we know you are doing your work, but we want it to be public. And if you want a public process, like you said, that is not the special prosecutor's outfit. That's not what they do. Nobody this work, and they present a half-yearly report.
Yeah.
Until that time is up, you can't be demanding that they should make things public. And they say that we don't make these things public because we don't want to embarrass and prejudice things against the people who appear before us.
I don't think that anybody put the the Office of the Special Prosecutor on the table in the press conference we did. We only asked for the further arrest of other people who are key government officials, who are state appointees. In fact, we didn't even mention the special prosecutor in our press conference. We just talk about further arrests to be made, because if you have 100 people committing a certain crime, and there's one criminal amongst them who is supposed to supervise for the crime not to be committed, our key interest must be on the one who is supervising. And we all know the 3 people who are mentioned, who have been mentioned either because of what Armiyawe has brought out Mr. Bisu, or whether what the report has mentioned the names, 3 names of Mr. Gabi, Kwam, Honorable Kwam, and then Lord Komi. We want all of them to be brought to the table, to be questioned before the public. So it will serve as a deterrent for other government officials who we suspect are part of this and are not mentioned, to be aware that the public are watching. We want a public inquiry. We want a public inquiry. We want to make sure the whole public is looking at them. They are listening to what is happening. The inquiry is made. The truth is brought out. People are questioned. You want to do this? Not Parliament? Parliament will not be a key factor in this kind of public inquiry we are talking about. We are talking about a bipartisan public inquiry, which will be set up with key individuals who we know can investigate the matter, the letter, and who we trust will not circumvent the truth, and who we believe will bring out the essence of what we are looking for. All right. Yeah. Honorable Atacha, you heard your colleague, and you have followed their press conference as well. What will be your reaction?
Well, my very good friend, Dr. Pelpuo, is struggling to justify the press conference. You see, I'm saying this for one simple reason, that Parliament cannot micromanage a special prosecutor. You cannot sit in the comfort of Parliament and begin to use press conference to stampede the special prosecutor as to how he should conduct his business. That would be very, very unfortunate, and that would be, as good as to say, an outrageous extension of the powers of Parliament. And the facts are showing a special prosecutor is working quietly, proud to the leakage of the Frimpong Boateng report. And the style of the special prosecutor and how he will do his work, half the time submarine work that he's doing, is not subject to a day-to-day parliamentary scrutiny. If not, then the special prosecutor will not be able to do his job at all. And I'm afraid if you said somebody, the special prosecutor should arrest A, B, C, or D of an individual, then it's an unfortunate dictatorship, which Parliament should never dare to do. Because state institutions, we know how to bring them before Parliament when they fall foul of the law and their duties. So I say that it is sad that the minority is trying to push the special prosecutor into doing things to appease them. When you mention Gabriel, Chedako, and the rest of them, it's all because of the political undertones. For instance, I've just heard him say that the government officials who are involved, because immediately you go that route, then the government should become very unpopular. Now you say you are fighting Galamsey, but meanwhile, your officials are neck deep in it. You know, it is a very convenient way to make people guilty in the space, in the court of public opinion, and that is sometimes the strength of politicians, that they push issues in the public opinion So people will look very, very bad because in the political space, they want to take advantage of the situation. So as far as I'm concerned, if you've never been guilty in the court of public opinion, I have been. And you should be careful in trying to say that government officials who are involved, Gabi or whoever, let's leave the special prosecutor to do his work. We've appointed him to do a good job, and let's leave him to do it. We should never stampede him through the power of press conferences in the comfort of a parliament. To achieve any result. It won't work.
You have said repeatedly that government officials or politically exposed persons, I will add that, who are involved. I think what has to be said is those who have been named in the Professor Boateng's report, because some of them are challenging these in the court. They have publicly denied the report to the extent that it seeks to indict them. But the substantive question to you is, don't you feel that the gravity of the situation actually requires a public inquiry?
Well, I think NDC will be strong to say that the appointer of the members of the public inquiry will be the self-same government. And that kind of ambivalence, with the greatest of respect, I can't accept. So right now, who will be the appointer of the members of the public inquiry? Is it going to be a C.A. Katia or Atachia? So, counsel, sometimes I get a bit worried when we want to virtually give political credence to every situation. So now we have the special prosecutor working on the matter. Let's leave him to work. Some people have been named in the document. I'm tempted to come to the conclusion that last week when I was listening to him, he says he's going to go full length, and nobody's above the law. Let's credit an institution with some credibility that they'll do their work. And if somebody is an MPP man and is neck deep in this matter, he owes it to his office to deal with him. And if an NDC man is also involved in it, he should do equal justice to the case.
The special prosecutor is only looking at corruption and corruption-related, aspects of the Galamsey menace, including the report. The special prosecutor has been clear. But are you not concerned that the president belatedly referred the report to the police for investigations? And on the side of the police, we practically have not heard anything about what it is doing in that regard, because it is the police that can look into the processes, including the report in full. The special prosecutor will only deal with a small aspect of it, so to speak.
Well, at the moment, we do not know the dossier before the police. And so far as the president has spoken about, I'm tempted to come to the conclusion that the IGP will be very sensitive to the promptings of the president. Again, we'll come back to the same point. Yes, I like the distinction you made. Corruption-related matters will be what is the remit of the special prosecutor. And then the police could go deeper outside that remit. But I'll crave your indulgence. This democracy has institutions undergirding them. We have democracy and we have institutions. So we should say that the IGP will respect what the president is saying and delve deep into it. But if we say that the IGP is quiet over the matter, let's wake him up with a press conference. Sometimes this might be desired. For all you know, some things are going on that we don't know. And I've told you, and I want to repeat it, it will be very unfortunate that Parliament is micromanaging the dossier of the IGP. That could be very, very unfortunate.
Or the OSP for that matter. Now, Dr. Pelpuo, one of your members, Roxanne Nelson Dafiamako, took this matter to Shraj. So Shraj is also supposed to be seized with it. All of that is not sufficient for you.
It's not sufficient at all. But just before that,
Police is investigating.
Let me get back to
OSP is investigating an aspect.
Yes.
Shraj is also seized with the matter.
Yes.
You said it's not sufficient at all.
It's not sufficient because, you see, you are dealing with an exclusive...
It's difficult for people to believe you are not doing the usual politics with this.
Let me explain to you why politics cannot be differentiated from what is happening. The president in 2017 made an announcement that he was going to fight Galamsey. He tied his presidency to it. It was a political decision. The president in 2021 April, took a decision and earmarked some red zone areas and said, look, these areas don't go there to do Galamsey or mining operations. The Minerals Commission, inconsistent with the president's pronouncement, issued about 6 licenses and operations are going on there. The rivers are being destroyed, the lands are destroyed, and the politicians are the same president is keeping quiet about it. Frimpong Boateng report is about decisions taken by himself, and the mess in that decision is being reported, and those are political decisions and the repercussions of it. So, if all these things are happening, and the public is unaware of what is happening, it is our duty to streamline issues despite investigations going on, to bring it to the fore, so we can sit this way as we are sitting. And again, we can have a public inquiry into it. So eventually, we can have a comprehensive approach to it and a non-political decision about whether Galamsey should happen or not. And I'm happy about the Bono region. The fact that citizens themselves have taken it upon themselves.
The Bebiani style, Doma style.
The Doma style have decided that, look, we don't want Galamsey here, we are going to prevent it, and it's working. We can stop it by something even going beyond political decision.
Interesting.
Yes.
But thank you very much, Bobby Banson. Bobby, so the Member of Parliament, Atachian, says, let's not seek to invite Parliament into the OSP's work. By the OSP's Act, in Section 4, even though it begins by saying that the office is not subject to the direction and control of any person or authority, Section 4, subsection 3, says that this, subsection 2 shall not preclude Parliament in the public interest from requesting the office to investigate alleged or suspected cases of corruption or a corruption-related offense involving public officers, politically exposed persons, or persons in the private sector. Do you find that this is what the minority were seeking to do? I'm trying to refine it for them somehow, somewhat.
Good morning, and it's really a privilege to be here with Dr. Pelpuo, having listened to him growing up, especially on this platform, and Senior Atachi as well. Greetings to him. And if the OSP had not said that he had already started investigating the matter, I believe that the parliamentary request as captured would have been relevant. Last week, I listened to the OSP on your platform, and he made it very clear that before the Frimpong Boateng report came out, his office had started investigating corruption-related aspects of the whole Galamsey menace. And so it is not as if the OSP just decided to start investigating based on Professor Frimpong Boateng's matter. So if Parliament, and Parliament is not only, it's not minority or majority. If the provisions of the OSP Act says Parliament may request the OSP in respect of this aspect of Galamsey, and the OSP says, I am already doing it, then it means that there will not be a need for Parliament to say, okay, we are directing you, because he said, I'm already doing it.
Right.
Particularly when the provisions of the OSP Act says that the OSP is not subject to the direction. Now, I think there are two things here. There's a difference between requesting the OSP to investigate and trying to teach the OSP how to investigate, who to investigate, how to arrest, and who to arrest. I think there are two different things, and I'm sure in the course of the discussion, they would come out clear. Because I do not think that it was the intention of the lawmaker that any group of persons or person would be in a position to direct not only OSP, but even the security agencies on how to do their work. That is why even in normal criminal procedure, if I'm a complainant, my work ends when I lodge the complaint and I give the evidence that I have to the police. But as to how the police will do their investigations, even who they will decide to prosecute, is completely out of my domain. If I think that they are not going against the person that I think I want to go, there are procedures that you can follow. So I think that, yes, I agree with the general cry that we all need this Galamsey to come to an end. And if they are politically connected or politically exposed persons who are benefiting from the menace, there should be a system where they will be investigated and properly brought before the law. I also want to link this because Senior Tachan spoke about institutions. You know, when ex-President Obama was in town some time ago and made this speech about Africa needs to establish strong institutions, I have always been of the opinion that it takes strong men to establish institutional framework that will outlive them. I think we saw the dispensation under the former OSP. We are seeing the dispensation under the current OSP. I believe the kind of, for lack of a better word, public bashing that the current OSP has received may vary in terms of nature from what the previous OSP received. But at least we see the public engagement by this current OSP coming to sit on your platform to explain to Ghanaians what he is doing and how, even to some extent, he is doing it.
2 questions, brief ones for your responses. First, you take the view that what is going on so far is satisfactory. There's been a report through the president to the police to investigate. The OSP is investigating the aspects that it has to investigate. And then Shraj is also seized with it. Are you satisfied with that?
I think to the extent that those are the institutions established by law that would have the jurisdiction to investigate. I think that so far all these 3 have been involved. I don't have cause to think that they will not do their work until such a time where they brought a report that is being covered by the powers that be, or there's evidence that the powers that be are refusing to cooperate. They would have a basis to say that they are being influenced to the detriment of the general population.
So the minority's request is needless. My next question to you is, so from what you are saying, the OSP, has it been satisfactory to you so far? There has been what you call public backlash. Are they informed, criticism of the OSP, or they are baseless from where you sit?
As a lawyer, without prejudice to all the facts that the OSP has, I was aligned with the public sentiment until I listened to him extensively on your show. That is what I'm saying. I was very satisfied or happy that he decided to do a public engagement through your platform. The whole concept was as if he had just picked only Professor Frimpong and that Rambo style. Invited like other persons that have also been invited, connected to this. I'm doing my work because per his act, he's required to publish a report of his work at certain times.
Half yearly.
And we are not there yet for him to say, this is the report of what I'm doing now. So I believe that we should wait for him to, he said, I started the process before the report came. Let's get to the half year and see the report he will provide on this. Then I'll be better placed to say, okay, as a layman, maybe I think he didn't look at it this way, he didn't look at it that way. But until then, let's allow them to do their work. That is my position on it at this stage.
The OSP is facing some difficulties, and one of the reasons we're happy to have you is that, you are good at your procedure and your law. So we want to help you, have you help explain. I'll come to you guys, but I need him to explain a few things. Now, the arrest that we continue to hear, that the Professor Frimpong Boateng was arrested. There was what people are concerned about, that the investigator touched his shoulder and told him that you are under arrest. What does that mean? in law, does it have any meaning at all? That was it important for the investigator to touch any part of his body?
Well, I have not seen any provision in the Criminal Procedure Code or Act. Sorry, they've now been turned into Act, or even the provisions of the OSP Act that requires that you are touched before you feel you are under arrest. Or
is that not a general practice to have a valid arrest? There must be a touching of the body of the suspect.
There must be a form of the suspect knowing that he's been restricted in terms of his movement at that particular point in time. And I believe that over the years, the practice has been, if you touch him to let him know that, okay, you can't move from where you are subject to these conditions, then they can say that, okay, you have been arrested. Now, I believe, because if it was to the contrary, it would have been said, that because per the OSP's position and per his law, when they are inviting you, or they are asking you, let me not use the word inviting, when they are asking you to report, if they intend to arrest you, the contents will suggest that you should do so, you should appear with them, to them with a lawyer of your choice. Because then you know that your statement will be taken. We know that in criminal procedure, there is the caution statement when they are investigating. And when they are investigating, they are finished, they have a prima facie dossier or docket, and they decide to go to the next level of arresting you, giving you bail, subject to further investigations. That procedure is also different. So I believe that when they requested his presence, and they must have told him to come with a lawyer.
Yes, they did.
They did. And I'm sure that the good professor went with a lawyer.
That is so.
And appreciated the discussions that went on there. I always say that the discussion that goes on sometimes in the public domain is as if the special prosecutor has conviction powers. It's as if once he says, I'm investigating you, it means that you've been convicted. But he has the power to investigate. He has the power to arrest and grant bail. So if he says that, okay, we are touching you to satisfy the legal requirements, which may be developed by practice, but I don't believe that an arrest cannot be effected without the touching of the body.
I've actually heard some people suggest that the special prosecutor doesn't have the power to determine bail and say, I'm granting bail and so on. I'm telling you, it's on social media. People are saying, where does he have the power to determine bail or grant bail and say that the man is granted bail in the sum of 2 million and so on? So this is a clear abuse of his power.
No, but the Special Prosecutor Act states clearly that he has all the powers of other security agencies.
Police powers.
Police powers.
That's what it says specifically.
Yes, police powers. And if the police can grant police inquiry bail.
That's right.
The law is very sacrosanct. They can do that. So if the Special Prosecutor, because you see, the reason for the grant of bail is to ensure your continuous cooperation with the officer or the security agent. So in this case, the special prosecutor. So if he says that we are granting you bail to the tune of 2 million cedis, and then we invite you and you do not come, and then they have the right to go to court to have the bail forfeited. It's just a security to ensure that you know that if you do not cooperate, especially with your attendance to their request, then there are consequences. So they have those powers.
Section 28 of the Office of Special Prosecutor Act 2017 says that the officers to exercise powers of police, the special prosecutor and authorized officer shall exercise the powers of a police officer specified in the Criminal and Other Offences Act, Other Offences Procedure Act 1960, Act 30, or any other enactment. So, okay, so that is not in doubt then. Now, the issues that have come up, and you have heard people, very respected people like Professor Stephen Adair, say that Professor Frimpong Boateng should not be arrested. He doesn't understand why he's been arrested and so on. But now there's another aspect of an individual that the special prosecutor is seeking to investigate who is challenging him. And in the course of this week, we understood that there was a court process to stop the special prosecutor. Explain to us, by your understanding, what has happened and how that sort of clips the wings of the special prosecutor in this process.
Well, from there, I had the opportunity to read the affidavit in support of the motioners party to secure that interim order to restrain the special prosecutor.
What does that mean, motioners party?
Okay, so the application filed by the lawyers of Mr. Charles Bishu asking the Human Rights Court to restrain the special prosecutor from effectively executing the arrest warrant that they obtained from the district court. So that was the application that was filed. And they didn't serve the special prosecutor to give him an opportunity to respond to it on the basis that their contention was that it was a very urgent situation and the special prosecutor has threatened to carry out the arrest. And so whenever if the court does not grant it for that 10-day period, the special prosecutor may go ahead and arrest, and then it will render the application.
I ask that because, again, in the public, people who do not know are reading meanings into it, that there's a certain collaboration to frustrate the special prosecutor. Is this a normal procedure?
Oh, it's allowed by law.
I can get up and go to court against you without you being in the court and without you knowing on your blind side, go and get an order against you?
Yes, it is allowed per the provisions of our Civil Procedure Act, particularly Order 25, that allows that in very special circumstances where the applicant or the person seeking that relief from the court would explain to the court that if you ask me to go and serve him, by the time I serve him, what I'm seeking to prevent may have already been done. And so grant me this order in the interim. That is why it is an interim order, only 10 days.
10 days?
Only 10 days.
Okay.
That within that 10 days, I will now go and serve him for him to come and respond to the merits of the case. So more or less, restrain him for only 10 days so that I have enough time to go and serve him. Then he can come and respond. That is why the interim order lasts for only 10 days.
Okay.
So if an application, that same process, if you don't file it again without serving the other side within that 10 days, then that process, that order has no force or has no moment after the expiry of the 10 days.
We understand they have gone against a warrant. From what the OSP is telling us, it doesn't appear that the OSP has actually gone to court for a warrant for him in this year. So what do you think is happening?
That was one of my challenges or my queries, curiosity with the application. Because if you read the application that was filed by the lawyers for Mr. Bishu was based on an originating motion that they had also filed in the same court asking for certain reliefs. Now, the reliefs that they were seeking from the substantive relief in the originating motion for their human rights breach were in respect of a purported arrest warrant. And so, remember, previously, the lawyers for Mr. Bishu had issued a writ of summons challenging the OSP's right to even investigate Mr. Bishu. That is one action. Then after the so-called arrest warrant came into public domain, the same lawyers issued another new action by means of an originating motion under Order 67 of the CI court rules to say that that arrest warrant was obtained in breach of the fundamental human rights of Mr. Charles Bishu. So the court should eventually set aside that arrest warrant. It was when they filed this originating motion that they filed the application ex parte. Now, everything about the originating motion and the application ex parte is hinged on the so-called arrest warrant. And so one would have thought...
They call it purported
arrest warrant. Now, one would have thought, as is the practice, that if you seek to invoke the jurisdiction of the court to challenge a process, you must adduce evidence of the existence of that process before the court. Because sometimes you and I know that judges do not make orders in a vacuum. So, for instance, I cannot go to court to say that Samson is threatening to slap me, and so he should be restrained, unless I have provided prima facie evidence of that attempted slap to the court. Otherwise, the court it will be an exercise in futility. Because one of
what you mean, simply put, is that in this case, the court should have seen the actual...
I think arrest warrant, yes. Because the grant or otherwise for an application for injunction, one of the grounds, is whether there is a real question of fact or law to be determined between the parties.
Let's make progress. What happens from here? You said it lasts for 10 days.
For 10 days.
So he cannot, if there is, that is if there is any such arrest warrant, it means the special prosecutor cannot execute it.
Yes.
By arresting Charles Bishu
based on that warrant
within 10 days from that day.
Based on that warrant.
Explain that. What do you
mean? You know, the application filed and the order from the court is restraining the special prosecutor from arresting Mr. Bishu based on that purported arrest warrant. The application and the order did not seek to restrain the OSP from arresting Mr. Charles Bishu. That is not why they went to court. No, if you read the affidavit and the release they were seeking, they are not seeking, we hereby pray the court to restrain the OSP from arresting Mr. Charles Bishu.
So that's why the OSP has issued a statement to say that it has power to arrest anybody without a warrant.
That is so, because it's clearly within the scope of their mandate that they can arrest you without a warrant, just like the police.
Are you saying the OSP can actually go ahead and arrest Charles Bishu?
From the evidence of the affidavit and the wording of the order, in my humble opinion, the OSP can arrest Mr. Charles Bishu if he sees him today, as long as the OSP does not say, I am arresting you pursuant to that arrest warrant.
A warrant?
Yes.
Which we do not know exists
on, because it wasn't exhibited to the application filed by Mr. Bishu's lawyers. And the OSP has also not made it public that indeed we went for an arrest warrant. We have not seen it. So as long as the OSP says, I'm arresting Mr. Bishu, but I'm not arresting you based on that warrant, I don't think the OSP would have breached or would be in contempt of the orders of this court, of the court.
Okay. Yeah. Well, they remain the orders, and until they have been set aside or vacated, it is lawful, and they must be complied with.
In terms of the order.
Interesting. Okay, so just seeking a little education for you, and I'm sure Bobby has helped us in that regard. Yes, there's another concern that the OSP issues wanted, that somebody is wanted, and they publish it. People are saying this is alien. We are not used to that. What do you know?
Well, like you read in section 28, the OSP has all the powers of the police service in discharge of its mandate. The OSP, in fact, has the power to request a party to be present or provide documents or any other assistance. If that party who has been demanded or requested by the OSP to appear or provide documents or cooperate in any form does not do it, that in itself is an offense. And that is a very unique part of the work or the mandate of the OSP.
It may be that the OSP is getting into the public. Otherwise, if you go to EOCO's, their pages and things, they issue this...
Even the police.
Wanted notices.
The police do that a lot. If you go to Central Police Station, you see notices, they have a notice board that if a complaint has been lodged, they are looking for somebody, the person has even jumped bail, they have a right to publish it, because you see, citizens have the right to also arrest persons. It's in the Criminal Procedure Code.
Right.
Every citizen, whether a security agent member or not, you have the right to arrest someone. So if you know that this person has been published as wanted, the OSP has told you we are looking for Mr. Kojo Mensah, and you see Mr. Kojo Mensah, as a citizen, you have the right under, I think, Section 8 of the Act 30, to arrest that person and take him to the office, either police or the OSP. And so it is not alien at all for the ASP to publish... OSP to publish
okay,
notices.
So the last thing I'll ask you about, then we move on to something else. I get a quick comment from my other guests and then we move on. It's being suggested, you've heard some criticism, that the OSP can be used by the government, particularly the Attorney General, who is a political person, because the OSP is not independent, and that the OSP prosecutes on the authority of the Attorney General. What does that mean?
You know, when the Act was in a bill form, that was one of the criticisms that some of us had of it.
Right.
But I cannot say that in the operation of the OSP's office, both Mr. Amidu and the current one, I have any inclination that they may be doing the bidding of the, because they've only operated within under the MPP government. Because Mr. Amidu, it was very clear that he said he was not happy with the corporation, so he left. Now this current OSP, he has gone against certain government appointees. The Mr. Bisu we are talking about is a known MPP person. Now, and this is where I think that I am a little bit happy with that provision, if the OSP completes a report and it says, the Attorney General says, do not prosecute, it will be published in his annual report. I expect it to be there. That I completed investigation.
That would suggest that the OSP goes to the Attorney General to ask, should I prosecute or should I not?
Yes.
Is that what the law says? In the preamble to the law, it says that it is to prosecute these corruption and corruption-related offenses on the authority of the Attorney General.
Yes.
Is this not usual in all other acts for these people or offices that must prosecute? Is it not the same in IOCO? Is it not the same for entities that are prosecuting? When they decide that I want to prosecute Bobby, must the OSP take the docket to the Attorney General and say, should I prosecute or should I not?
I do not think in practice and in operation that is how it works. However, the Attorney General, by this provision, can have a right to stop the prosecution. In the IOCO instance or the police instance, if the Attorney General's office writes a letter addressed to the police department and says that bring me this docket, it means you cannot take any step without it. And so the act was very also clear, like you said, on the authority of the attorney, because I think because of the wording of Article 88, that once the OSP will be prosecuting in the name of the Republic, and Article 88 says that it is only the Attorney General that can do that. It means any person that should do that should be riding on the authority of the Attorney General.
So in Ghana, by our Constitution in Article 88, specifically Article 88, is it 1?
Yes.
Article 88, 4. No criminal prosecution can go on unless in the name of the Attorney General.
In the name of the Republic.
Okay.
But that power to prosecute has been vested in the Attorney General. And so you will now be doing it under the authority of the Attorney General. Okay. It doesn't mean that you should go to the Attorney General with every docket, but it also means that the Attorney General can stop you from doing the prosecution.
Right. So what then becomes the meaning of Section 4, subsection 1? It says, except as otherwise provided in the Constitution, the office is not subject to the direction or control of a person or an authority in the performance of the functions of the office. Then 2, subject to Clause 4 of Article 88 of the Constitution, the office shall, for the purposes of this Act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offenses. And finally, 3, subsection 2 shall not preclude Parliament in the public interest from requesting the office to investigate alleged or suspected cases of corruption and so on.
And so the powers of the government, as we made, there are 3 arms of government. All the powers in Ghana is exercised through these 3 arms of government.
All right.
And so if you say subject to any other provision in the Constitution, one would think we have the executive arm, the parliament, and the judiciary. Of course, the judiciary is not relevant to this discussion. I believe that the 4.1 may have been targeted directly to the executive, that you do not have the executive having the right, because the OSP is nominated for
to
appointment.
Direct or control.
Yes, by the president.
Can't do that.
No. However, I know the executive arm of government has no jurisdiction whatsoever to direct the OSP as to who or how it should go about its work. But because of Article 88, which is still in the Constitution, and every other law that contradicts the Constitution is a nullity to that extent.
Okay.
The framers could not have provided for Section 4 without taking into consideration Subclause 4. Other than that, somebody would have gone to the Supreme Court to challenge it.
Okay.
That if you say that the OSP is independent...
So the law says you can't control, you can't direct the OSP.
No.
But you say, he can say, stop this investigation.
Yes.
If they do that, is that not directing and controlling?
It is, but that is the Constitution as we have it. But that is where I was going to. That if the OSP faces any such control from the Attorney General, he should put it in his report.
All right.
So that the people will judge.
Thank you so very much. Now, let me take your final wrap quick wrap. Let's start with Atachia. Yes, what do you have to say?
Yes, Samson, I should say that we're a very clever man, that he brought a lawyer to be in the middle so that what he's saying will not be like this, an MPP manifesto and then this manifesto. So I have to congratulate you on your refereeing powers. It's very, very, very solid. And what Council Bobby Banson has said is very valid. But I have a problem. My problem is whatever the tactics are, whether you want to use a Maradona of a lawyer in trying to prevent arrest, in the court of public opinion, people begin to ask why Boateng has gone there. What not about you? So what I see, and I say clearly, that if you pay regard to the same constitution, Article 14, 1G, the constitution provides every person shall be entitled to his personal liberty, and no person shall be deprived of his personal liberty, except in the following cases, in accordance with procedure permitted by law. That Jesus, upon reasonable suspicion of having committed or being about to commit a criminal offense under the laws of Ghana. So there is no immunity from arrest. So if you have a 10-day spite or whatever there is, I'm afraid you have to submit yourself to the special prosecutor. And then what is needful will be done. My only concern is that people might read meaning into what a lawyer is doing to prevent one person from arrest. Is he guilty? Why is he trying to use the powers of the court to prevent himself from being investigated? So I believe that no matter what it is, eventually there will be an arrest, if that is the pleasure of the special prosecutor. And we should be careful we don't give the wrong impression that, oh, somebody's above arrest. It will be against the Constitution. And then I really want to talk about this direction and control. It's a very, very, very interesting provision, because at the end of the day, as you have really read, the Constitution is clear that every criminal action shall be at the suit of the Attorney General. So therefore, you've posed a very interesting question. What does that mean? If at the end of the day, the OSP wants to go this direction, the Attorney General says, no, go this direction. I don't believe that is a case that you prosecute. That will be the end of the matter. And the way we place meaning on direction and control, probably this matter will have to go to the court for them to give us an interpretation. Because I'm saying, you are very, very deep in your saying that when you use this word control and direction, at the end of the day, are you not trying to checkmate the work of the OSP? And by the sheer fact that you do your half-yearly report, would it cure the mischief that a very strong Attorney General will say, look, this case is clear that somebody has a case to answer in court, but I will not give you the power to go and do what you are attempting to do. So I think there's a challenge with this matter, and probably one of these days will be tested in the Supreme Court.
Okay. Thank you for your views there. Yes, Dr. Pelpuo.
Yeah, thank you so much. Let me start by stating very clearly that Parliament or the minority will not be restrained by any investigations of any matter going on if we have a strong belief that by bringing it to the public notice and by making pronouncement of it, investigations will be swift, and the public will be interested in the finality of it, and that issues will not be swept under any carpet at all. So what Honorable Atachia has said by saying it's not necessary because the investigation was going on, supported by my good friend Bobby, well-informed man, we reject it. We insist that if there's any matter is within the interest of the people, we definitely will have the right to go on and mention it. We have accountability to the people. That accountability goes beyond any other issues that fall outside the wish of the people. Yeah, I mean, we will not be restrained by the will of, to go outside the will of the people.
Right.
And again, because of our oversight role, whether matters are investigated or not, to perform that oversight role, we definitely will often mention these things, as a result of what we are doing, not because others are doing it, but because of what we should be doing. And so our requests are touching on increasing the arrests of the people that had been, or of the person that had already been arrested, is to ensure that there is simultaneous investigation in everything that is happening. You remember that, or you know, that when government officials are involved in an issue and they are not tackled very quickly, by the time you realize they have an influence on on how matters finally come into being. So we often will say that, look, it's important that when we are doing this, it is to widen the scope and it is to make sure people don't investigate, don't tamper with the investigation going on.
All right.
And the last thing is that if Mr. Charles Bisu knows that he's not guilty of anything, and he's invited severally, he's not going, why is he stopping anybody from arresting him? Why is he saying that the arrest warrant should be offset?
We are a democracy.
Yeah.
And we are under rule of law, due process.
Yes.
Everybody have their rights to go to court and assert what they think is right. He's in court saying that he's been investigated on the same or similar matters by police and so on, and therefore the special prosecutor should not investigate him again. Let's leave the court to pronounce on that, whether he should be investigated or he should not.
Okay. Right. So for us, going into this matter by the Office of the Special Prosecutor is something of interest to us.
All right.
And we want to work along with the people to make sure these things are properly.
We're taking a break, but before we do that, just a quick few of your messages here. And I'm sure that you have been educated also by Bobby Banson in the issues of arrest, the mystery that is being put to being the man's shoulder being touched. In our law, it is called Act 30. It says that for police arrest to be a valid and proper arrest, actually there's a police arrest you can resist. I've used my take to teach you about that. If they don't follow the procedure, you can resist it. And one of the procedure put down by law is that in making an arrest, the police officer or any other person making the arrest shall actually touch or confine the body of the person to be arrested unless there is a submission to the custody verbally or by conduct. So this is law, and I'm sure you are being educated. A couple of your questions. Ibrahim Sumani says the OSP's approach to corruption-related aspect of Galamsey menace will not take him anywhere because he can't turn those who sacrifice their lives to be whistleblowers to be his victims. It creates room for the real corrupt people to be shelved. Okay. Little Tete says education must guide us from careless beliefs to morally sound judgment. It must guide us towards logical clarity. More of this education from the OSP will be welcome, in my opinion. Maybe a TV program called Time with Special Prosecutor might enlighten us all. I invite you to the law show tomorrow here on this same platform at 2 p.m. We're engaging two senior lawyers, Lawyer Opokwe J and Musa Ahmed, to just explain the OSP's law to you. So please join us 2 p.m. on the law. Mashoud Mohammed said, until we understand that all politicians are members of the same club, indeed, politicians won't stop Galamsey. They are playing a game. Edward Dubaza says, we are waiting for the special prosecutor to invite Chairman Wuntumi and tell him, quote, you are under arrest, end quote, as he did to Professor Frimpong Boateng. It appears Chairman Wuntumi already went there himself and submitted himself in the first case. Wise Blaze says, per the article it is abundantly clear that the bar stops with the Attorney General, and this ultimately will affect the work of the OSP. Derek, 45, says the problem with this country is how we attach party colors to problems in this country, and the political credence people are giving to the Galamsey war is problematic. And then LGD, Holy, says we often say, quote, if you fight corruption, corruption fights back, end quote. Can it be said that those fighting the work of the OSP are against the fight against corruption? An interesting question there. Musa Abatwa in Kumasi says OSP is working, but until he's able to investigate big fishes mentioned in the Professor Frimpong Boateng report, I won't consider his work successful. Going after Charles Bissiou is peripheral. Edward says that when does the half yearly starts and ends? So it's a question. I have the law here. Let me just read. I don't know. I think it's a section 3. Forgive me, I'm going for a break. Section 3 of the OSP Act. Section 3, subsection 3. Subsection 3. Yeah. Okay. Subsection 3 says that the office shall, on a half-yearly basis, publish the following information in at least 2 daily newspapers of national circulation and on the website of the office. A, the list of corruption cases investigated and prosecuted by the office, and B, the number of acquittals, convictions, and cases pending in respect of the cases prosecuted under paragraph A, and the value of proceeds recovered, if any. So I hope that helps. So he says from January to today is the 6th month. The OSP should publish the names of the people who have been invited or arrested. Transparency is the hallmark of every government and institution like the OSP. Since he started the work in October of 2022. Thank you. That's an interesting one. Kofi says, the police were tasked to investigate initial allegations made by the good professor in an interview with GTV. He submitted a report he wrote a couple of years back to the police when he was invited for the investigations. Leaks take place all around with party people denying allegations made against them in the report. Then the OSP jumps once again into the matter. So what has happened to the police investigations? They have they spoken to Prof, safe collecting a report from him? What about the persons named in the report? The police owe us a duty to tell us what they have done so far. Thank you for those messages. I'm sorry we're unable to read anymore. We'll be right back.
We are calling on Parliament to institute an inquiry into the matter because the chiefs and people of Botiano and Kokrobite have rejected the claim by the police. We believe strongly that an inquiry could bring out the truth of this matter and bring calm to the people of my constituency. I will also urge the people of Botiano, Kokrobite, and the surrounding communities to remain calm and continue to be law-abiding as we allow the competent, relevant state agencies to take up the matter and ascertain the veracity or otherwise of the claim.
Was it for the police to shoot them to death or to attempt to apprehend them and bring them to justice? Mr. Speaker, I think that the proper thing that ought to have been done in the circumstances was for the police to have attempted to apprehend the suspects, because our criminal jurisprudence is grounded on the presumption of innocence.
Police service inquiries are not enough, but if it becomes a parliamentary inquiry, then they have a new set of individuals, members of parliament, probing the matter. And that is when the members of parliament can finger waywardness in the name of policing, and then deal with the officers who, by every calculation, may be responsible for unlawful killings of individuals.
We are making the referral to the Committee of Defense and Interior, and we are asking leadership of constitutional and parliamentary affairs to also join the Defense and Interior Committee to look into this matter and report back by the end of this month.
Right, so you just been listening to what took place in Parliament, and of course we know that the police issued a statement and about the shootout at the Botiano, and in the statement which dated the 10th of June, they said that the 5 were suspected land guards. The 5 people in this matter were suspected land guards who engaged the police in a shootout when the police visited the area. It says the police conducted an operation targeting criminal elements involved in robbery and land guard activities. These individuals had been terrorizing residents and landowners in Botiano and nearby communities. They also explained to us that upon detecting the approaching police team, the suspects opened fire from their hideout, prompting the police to retaliate. And that as a result, 5 of the suspects were injured and later pronounced dead at the hospital, while the remaining suspects fled the scene and are still at large. According to the police, they had various weapons, including guns and ammunition, that they seized from them. They included 1 AK-47 assault rifle, 10 rounds of AK-47 ammunition, 1 pump-action gun with 9 rounds of BB cartridges, 2 pistols, and 10 rounds of 9 ammunition, and 1 unregistered Toyota Tacoma pickup, 4 motorbikes, 3 of which are unregistered, a knife, and pepper spray, the police reported. Now, it is the police against the chiefs in the area and the elders in the area and the MP for the area, Sylvester Tete, who have all been complaining that these people are known sand winners. They are not land guards, and they have been doing their lawful duty. Let's begin this discussion with Kwame Jan. Kwame Jan is a lawyer who, when it comes to looking at the questions of land matters and questions of land guards, foremost in this country. Thank you so very much for making time to join us, Kwame Jan.
Thank you very much, my brother.
Right.
I warmly greet all your listeners.
Right. As a practitioner, a teacher of the law, even the one behind, the making of some of our laws in this regard, we know that land guard activities are criminal by even the Land Act, which was passed recently, also the Vigilante Act or so. These are criminal activities. So why do you think that the MPs, the chiefs, and some members of the public are questioning the police in what they have done?
Thank you very much. In this country, there are many cases where, because of political expediency, particularly MPs, because of vote and staying in office, particularly MPs and in some cases politicians generally, would not want to face the fact I have been around the land sector in this country for the last 25 years since I came back from my studies abroad. And I have been very instrumental in putting together the legislation for the land sector lately, particularly the Lands Commission Act of 2008, Act 767, and the Land Act of 2020, Act 1036. You know, my brother, this thing called land guards, apart from the killings and the maimings and so on, land guards present a serious security issue wherever they are found. They negatively affect the value of properties. If you live in an area with prevalence of land guard activities, property values are low. Because who wants to be part of such an area? But the problem with land guards is, if you look at the Land Act, there is no reference to that word land guard.
Right.
It doesn't appear anywhere in the Act. Because this thing called land guards, they are multifaceted. You know, there are some people who are like area guys. You know, they are sons of the soil. They are members of the land-owning group. They will just come around when you are developing. They will say, "Fei kusum, do kusum," particularly in the Ga areas. Do kusum. If you do the kusum, they are harmless. They will just take some peanuts and they go. Yes, their activities are also criminalized in Section 12 of the Land Act, but they don't present a clear and present danger. But how did we get to where we are with land guards? Predominantly, land guards were started by landowners who, because of insecurity of title and tenure, brought in people to come and support them in their contest against their adjoining landowners. And they have stayed and overstayed. So land guards were made by landowners. That's why you have, if you watch, anytime there is police land guard issue, you will see landowners coming on the side of what they will call the victims. Because land guards are made by landowners. They are made by landowners.
Shouldn't it be easy for the populace to support the police in these kinds of, their operations, especially that we know as a matter of fact, particularly in our towns and cities, especially in Accra, that land guards are known to terrorize law-abiding landowners, and they are often wielding guns and the sort of, weapons that the police talk about. So why is it that when this happens, the public is rather in a hurry to doubt the police?
You'll be surprised. That is why I was telling you, the land guards are made by the landowners. These guys are known, their activities are known, they are scattered in, like I tell you, I know key areas within the environs of the national capital where they predominate. My brother, they predominate generally around the areas we call the peri-urban areas. The land guards are very active where land conversion is taking place. So where land is converting from being used as farmland to residential and commercial development. So they are predominantly in the peri-urban areas. And the landowners know them and they use them. So whilst they are doing their bidding, the landowners will always come and defend them. Now, as for the public, who besides you if you pointed at where land guards are located? Because the public know that if the police arrest them, they will come back to the area. And who besides you? They will know who pointed them out, and they will come and finish you.
Yeah. So
the public are maybe grudgingly keeping quiet. Not that they are happy.
No,
but the landowners who are using them are happy.
We know that the land guards are a threat to us, and we want the police to protect us. And yet, we are fighting the police, quote unquote, for fighting them in the manner they have done.
See, because some of the people who are talking have not had encounters with land guards. And you know, these are guys who have influence in their areas. They have influence in their areas. So when they are taken away by the police, you will certainly find some people in the hoods who will come in support of their system. They are not alien to the people. They live among them. Everybody in the area knows that this is what they do. And you know what else? It is the same group and groups around Accra who are involved also in the robberies. They do land guard work in the day, and in the night they are armed robbers. So there is an inexplicable link between robberies and land guardism. And it is inexplicable. And there is also an inexplicable link between these same activities and the chieftaincy issues across the country. It is the same guys who are ferried to go and fight in chieftaincy issues in this country. The same guys.
So
the same guys.
How will you propose that Parliament, in looking at this issue, what should they be mindful of, and particularly to the residents and the leaders in the Botiano community? How should they cooperate with police in going forward? Because they are not happy. They say these guys that you have shot and killed are not land guards. They are involved in sun winning. The police say we found these weapons with them. Why are you carrying these weapons? The police say they were shooting at them. But the police don't tell us if any of their members, got hurt by any shooting.
Yes, but you see, that's the reason when we were putting together the law, we didn't use the phrase or the word land guard. Because who is a land guard itself becomes problematic. The law, Section 12 of the Land Act, proscribes certain activities. So, for example, if you go to land in which you have no interest, and you purport to stop someone who has interest in the land from developing the land, we don't call you a land guard in the law, but the activity is prohibited.
That's right.
So there are certain activities which have been prohibited. And the question is, are these people involved in any of the prohibited activities in Section 12 of the Land Act? Are they involved in any of the prohibited activities? And it takes you back to the Constitution. Yes, everybody in this country has a right to life. But Article 13 of the Constitution sets out the limits of your right to life. That under certain circumstances, your right to life it can lawfully be taken. So ask yourself whether the information the police are giving, is it commensurate with any circumstance under Article 13 in which they can shoot to kill? How many people have been land guards killed in this country? How many people haven't died on their own lawfully acquired lands? And how many of these people have ever been prosecuted? It started long ago from Ablekuma, when some policemen, Ninja and others, some ECG top executives, nurses were killed at English Yaman from Domiabra. It's so rampant, so rampant. So rampant. Yes, it's painful when anybody is killed. But the law expects that under certain circumstances, life will be taken away. And if life has been taken away, we should just interrogate the facts. Are the police justified under Article 13 to take out someone's life? If they are justified, they are justified. You see, you are running this country into a state where law enforcement is gradually being incapacitated because of all these kinds of agitations, because of vote. vote. Everything in this country is seen in the lens of vote. So people do wrong things, but because you want them to vote for us, we support them. What kind of country are we building?
Okay. Thank you so very much, Lawyer Kwame Jan. He's a senior lecturer at the University of Ghana. And like I said earlier, it's unquestioned. In this country, he's foremost land law expert. And he's written volumes and volumes. And he's been a central part of our laws as far as the area is concerned. So he knows the law in and out. Now, let's find out if the members of parliament who took the floor and spoke and raised suspicions against the police because of the police's own past history. We have had a situation in Kumasi, in Ashanti region, for example, where police, were found to have told a lie in a situation where they killed people. They brought out weapons, ammunition, and claimed they belonged to those people. And the committee found that that was a lie. So those people had to be compensated. Is that enough basis to continue to be suspicious of the police when they say we encountered people who shot at us, who are doing land guard activity? And like Lawyer Kwame Jan said, land guards have killed many people in this country, deprived many people, have maimed many people who have lawfully acquired land in this country. Atacha, let's start with you. You were heard speaking, and now two of the committees of parliament have been asked to go into this matter. To what end? Are you not discouraging the police in this process, in their fight against crime?
I have enormous respect for Lawyer Kwame Jan, and I do not support his opinion that because of votes, people want to bring to the fore the necessity to investigate a subject matter that human beings have died. So please, that drumming home this issue of votes, I'm telling you the truth. The NDC and the MPP have converged on a matter, which is to say that we've lost human beings, let's pry into the matter. And we are saying so for the simple reason that we might not want to say that land guards are not dangerous and a menace to society. We are not saying so at all. And at the same token, we are not saying that we have our saints in the police service. We are not saying that at all. Because every human institution is stamped with imperfections. And insofar as we cannot know in advance what are the content of this violence, that is what the inquiry is necessary. And I want to stress that. Today, the version you've read, their lives were in danger. We know that as a fact, that when your life is in danger, you are permitted by law to defend your life. It says so in Article 13 and it's right. And then you also pose a question that, was there any attempt to shoot back? If the police wanted, if their life were in danger because they shot at them, did they also shoot back? Was a policeman hurt and the rest of it? Trust me, we don't have video evidence of this escapade. That is why it is imperative that we have an inquiry in relation to this matter. Now, let me tell you something which is very important. There's what they call the police service inquiry. When I was practicing law seriously, I've been into some of these inquiries where the police themselves have sort of arraigned another policeman for his waywardness and the rest of it. It has come out as one of the ways to bring discipline to bear on the service of the police. But I'm of the humble view on hindsight that if we're not careful and the police are investigating themselves, then there could be issues of bias and the issues that we should look good to the general public. And even the penal consequences of somebody's actions might not be as strong as it would have been if it were in the hands of other individuals. That is why the call that this matter should have independent investigation is very, very good. And we have also the situation of a history in which some of these police killings are becoming too many. Bear that in mind. Because now, if, as Lawyer Kwame Jan is trying to surmise, the Langas are in the community, they are known, they even find the activities in chieftaincy matters and do armed robbery. Does the police know this? What he's telling us? And therefore, there is another development of policing in which there is not this ambulance arrangements that should engage the attention. The police should be very powerful and have community informants, and also they do submarine investigations, and they will nip crime in the bud ab initio.
Is that not the case here? Is that not the case here that they may have been following on intelligence, and then they swooped on these people at the time when they had all these weapons and allegedly shot back at them? And Kwame Jan asked the question again. Article 13 of the Constitution, particularly Clause 2, whilst the law says human life is inviolable and no one's life should be taken, it says that there can be justifiable reasons why human life could be taken, including for the defense of any person from violence, or for the defense of property, or in order to effect a lawful arrest, or to prevent the escape of a person lawfully detained, or in order to prevent the commission of a crime by that person. That it says that the police, there could be a lawful force that could be brought to bear, which is justifiable.
I agree, but I'm telling you that when you talk about intelligence, is the intelligence in the ambulance chase and the theatrics, or the intelligence who even nip the crime ab initio. So when you have intelligence and the community is showing that these are the individuals and these are activities, then it doesn't start. You disarm people before, excuse me to say, they go on the crime undertaking. This is what I believe should be the specialty of police service. Because if they claim they have intelligence, but the intelligence is only used in the theatrics and the killing, then what is the sense of the intelligence? That's what my chief concern is. So if you have intelligence, now some crimes can never start. By the time people say that they've taken their cudgels and things, and even where they are buying their bullets from and the rest of them, they've been arrested already. So we don't see these things going. But be that as may, for my part, I am of the humble view that what the Parliament of Ghana is calling for is eminently sensible. We should go into this matter and let us come out with the findings. And then the general public will know. If we gather very serious findings that will aid the police in their future conduct, so be it.
Great.
But to say that, it is only the version of the police that should hold sway, I'm not in agreement. In fact, what you read to, the general public, the press release, I don't want to say that I want to run down the police. But there are a lot of loopholes in the press, release dated the 10th day of June, 2023. And let the measurement of the police should not be the police themselves. Let Parliament also look at this matter, and we're better off for it. If you are not culpable, you are not culpable. But if you are culpable, then let's send the signal that in the name of holding the powers of the state, life should matter to you. And it's under extreme circumstances when the law enforcement officers themselves have their lives endangered because of operations, that these killings will be justified by law. That is all that we are saying. Nobody is saying that, we're trying to weaken the powers of the police by what we are calling for. That would be very, very unfortunate.
Land guard activities continue to, to happen, to be rife in the places that Lord Kwame refers us to, and we know them. Do you think the laws are not biting enough, even though the recent laws that have been passed, criminalizing clearly land guard activities, have taken the sanctions to such heights? People can suffer many, many years, a dozen plus years in jail for land guard activity. And yet, this thing goes on. It doesn't look like it's abating.
Yes, because it's not the law per se that will contain behavior. We should know that sometimes the law functions post behavior. That's when somebody has been arrested and we try and arraign the person before a court of competent jurisdiction for the person to be dealt with in accordance with law. But what is essential, Council, is that we can do a lot of policing and stop some issues happening before we come and complain that, we knew that some people are in the peri-urban areas and their vocation is land guard activities. But because when you speak like that, you're giving an impression as if you live with them, but you are impotent to deal with them. If you capture all these intelligence, summaries, it's like, we know where they are. They are blended with the society. They live there. They are involved with chieftaincy matters. They also do armed robberies. And these people, if you know this is their vocation, their criminal activity, why is it that you can't disarm them before they function? And that is it. That is the real, challenge with the Ghana Police Service. They should go into these submarine activities, and those who are rehearsed criminals and patented criminals are dealt with before they inflict pain on society.
Okay. But my final question to you, I'll be remiss if I didn't ask that question. Are you as concerned over the matter of the Ashaiman military brutality, which was clear, unconstitutional, illegal conduct by the military against the poor people in that community, as much as you are with this particular one?
I was extremely concerned, and I was on the floor of Parliament saying that you do not brutalize the innocent to find the guilty. It's on the side. I was scandalized that if some people have committed crime, should we punish an entire community in the hope that we find the criminals? It was a very outrageous situation we find ourselves. So we are not trying to sort of, do selective advocacy. It matters when Ghanaians are affected. We'd have sort of devalued our office as members of Parliament.
In this case, you are doing more than advocacy. You are going to investigate.
Sure, we should push it to that length because we don't find Parliament going that full throttle.
Yeah, so that's the question. Are you investigating the arrest of over 180 in Ashaiman and how they were brutalized, clearly abused?
I cannot say on top of my head the final conclusion of the House when we finish the debate. But it does not even stop us right now by your own prompting that we should hold the military to a committee of Parliament and let them explain away why they were beating the innocent in the hope of finding the criminal. It doesn't stop us anything. And I am not worried at all when we are jolted into action. Right. So I think what you brought to the fore, I could come back to you and find out what the Hansard said in relation to that military brutality. It was unfortunate.
Yeah, we are aware about your comments at the time because out of many, particularly in government or with the governing party, you were sort of, an isolation, so to speak, in dealing with the truth as it is. Yes, Dr. Pelpuo.
Thank you so much.
This one too, were you heard speaking about it? James Agalga, you were all united.
We were united in that action,
yes.
Because
a member, a colleague of yours brought the matter and said, 5 of my people have been killed by police in the name of land guards, and the information I have is that they are not land guards.
Not necessarily because our colleague brought it up, but essentially because we detest any situation where the police, rather than directly arresting people will kill them even before they are investigated. It is something that Parliament is thoroughly against and will always call for further investigation. But Samson, this tells you that Parliament is a unique body, a constitutional body with its own character.
You said police rather than directly arrest people. You know, it is not all the circumstances that they would have the opportunity to effect an arrest.
That's why
they say they were met with firepower.
That's why we are calling for investigation. In fact, it's time for the IGP, the police service, to mount policemen who are going on operations with cameras. So when they are operating, like happened elsewhere,
they may not have enough, but they have some of them, we understand.
Yeah, when they are operating, but in matters like this where shootout is likely to happen, they should demonstrate
especially
that,
when none of their officers is hurt as evidence.
Yeah, so I mean, they should have shown that something is happening, but it's the reason we are calling for investigations. But it also gives truth to what I said, that Parliament will investigate or Parliament will comment on issues even when they are investigated outside. Otherwise, we would have said the police is investigating. Why are you, Parliament, making a statement about it? I mean, I think you understand that. So if we make statements on behalf of the people, it is a necessity, it is in accordance with our common principle of representing the people. And so this matter is of direct interest to us, and that we want this matter to be investigated. Let it be proven that the people who are attacked and killed are armed robbers. Let it also be proven that they were met with arms, and what happened was just a retaliatory attack, because meeting police with arms is completely unacceptable. The police represents the state, the authority of the state to act in accordance with the laws of Ghana, to protect people and to ensure that people can live in freedom. So when they are pursuing their objective of arresting or preventing a crime, and you meet them with arms, you are simply calling for...
Other experts have said the police is trained, like any other security agency, to shoot to disable, and not to shoot to kill.
Definitely.
And in this case, all 5 gone.
And that's very, very, very unfortunate. In fact, it's unacceptable. And that investigation we are calling for must establish some true situation which should inform our future actions. Because, I mean, we are amazed, we are surprised, and we are taken aback by exactly what happened, that you are trying to stop a crime, you are trying to get people arrested, and then all 5 of them are killed. None of them is available for you to take to court to answer any question, or to even be given further, to investigate them further, to get to understand exactly what they were doing. So
and like Atachian said on the floor, this situation where something happens and the police is investigating itself, what can you, as Parliament, do? Because there have been, civil society groups like One Ghana Movement, who have done papers and asked that there should be an independent commission that investigates police conduct and not the police investigating, itself. I've attended some of these things to represent either a police officer or be part of it for the ordinary person, and it leaves very much to be desired.
That's true. It still leaves a big gap between the police and what we believe in them. Our belief in the police, what they achieve in investigations, and the actuality of it, there's still a big gap. And so that tells you that they need to convince the public more that in times like this, they can be independent, they can provide independent views about issues and bring them out to the fore, so we understand them to be reflecting the real situation.
Okay.
So,
what can you do?
In truth,
because we keep complaining that it's not a fair process.
Yes. So until they can be objective, I have a lot of confidence in the present police, IGP. I think that he should put in place a certain system that can convince the public that when they investigate, it is the truth. Because I've also had situations where people are arrested, you go to find out what their arrest is, they have said things that people deny that it is true. And the police must be objective in what they do. And so the call for it is necessary.
In fact, it's also worrying that the Commonwealth Human Rights Initiative, an NGO, which has been following reports of police misconduct, that the police have issued a statement and said we are investigating. They filed an RTI request seeking to know, and they listed a number of these occurrences where the police had told the whole world that we are investigating, and asked the police, give us updates. What happened in this investigation? What happened in that investigation? The police denied them in the information, just didn't give them the information. And they are still trying to pursue that. Let's see how all of that goes. But we'll take our final comment from Lawyer Kwame Jan. Having heard from the two MPs, what will be your final comment, particularly on how the police and the community may be able to work together going forward, because you also need police protection?
Thank you very much. I know the two honorable members very well, and Father Atachia is my countryman. And the honorable, I know him because of WA. I know him very well. We are very respected members of Parliament. You see, generally, there is a lot of mistrust of public institutions across the country. Parliament has the oversight responsibility over all these matters because they are the representatives of the people. But there is also public mistrust about Parliament, like the other institutions of state. So as a nation, it is about time we do those things to bring public trust and public confidence in our institutions. I mean, all the institutions. Where I work at the University of Ghana, everywhere there is mistrust. And it is incumbent on all of us to do those things to engender public trust and confidence in state institutions. This will lead to a mitigation of we don't trust the police, we don't trust Parliament, we need to do things to reduce this perception, if it is a perception. If it is real, we still have to do something about it.
All right. Thank you very much. And before we take a break and return for our next and final subject to discuss, and this time it is a press conference by the majority, led by Atachia, and not by the minority, led by Dr. Rashid Pelpuo. Pa Kofi Letsa says, so surprised at the position of the MP. Let them do a survey, and I can bet that the majority of the people around the area of the incident are happy with the action of the police. These guards are known people in the area that are always released when arrested. I have a bad experience. Sadiq Abubakar says the politicians know the truth, but are always quick to dance around the truth. Almost all the sand winners are the same land guards. Thomas Asako, I'm surprised at the comments made by the senior lecturer. We can't take the word of the police as the gospel truth. The Asawasi incident is still fresh in our minds. Nanai Kuyai Jewa says, these land guards are problematic at Bawe area. They are very dangerous. But the sad thing is that they are protected by the chiefs and police at Bawe. Latif Idris did a full story on how police were actually neck deep involved in this kind of thing. Don't dreams. You won't understand until you come into contact with these land guards. It is a fierce and dangerous situation if you come into contact with them. If you are able to survive in their hands, then you might be serving a living God. Vine Maxwell says, I condemn every killing of our people. If the suspects really fired at the police is mandated to use the last resort of rules of engagement. If they weren't armed and no evidence cogent enough to support the police actions, the laws must be allowed to prevail. Citizen Marcy says the landowners are protecting their boys. Nanaya Opare, if only you know how happy people in that area are. Baba Chairman, in as much as I condemn the police for always killing people before they are investigated, I equally think it is wrong for anybody to suggest that a police officer should be killed or injured before we believe them. Thank you. We'll be right back to look at the questions of take or pay energy contracts and the ballooning debts said to have contributed to our economic situation, leading us to the IMF, and now potentially triggering another era of doomsday. Newsfile is brought to you by the candid sponsorship of Bank of Africa, as strong as a group and close as a partner, MTN everywhere you go. Ashasi University, educating ethical and entrepreneurial leaders for Africa. Robert and Sons Optical Services, your comprehensive eye care service provider for 31 years. Duraplus, how you get your water matters. Remember, where Duraplus goes, water flows. DBS Industries, roofing, Papa Fie. My Way, you dial *165# on the MTN to join My Way today. We'll be right back.
Since the Mahama government left office at the end of 2016, every single power purchase agreement, or indeed fuel purchase agreement, the Tema LNG project, has had a take-or-pay component. Take-or-pay is a reality in our situation because of confidence. A 330 megawatt combined cycle plant on the average will cost about $500 million in our sub-region. Is the country director of World Bank saying that the IFC, International Finance Corporation, which is an arm of the World Bank, are they saying they will fund a project worth $500 million and not demand a guarantee or an offtake agreement? I wish the country director had gone a bit back or gotten his researchers to look at the whole.
Even before President Mahama, most of the thermal plants had capacity charges. Just to cite a few examples, Asogli had capacity charges, TICO has capacity charges, Sen Power has capacity charges, Senate has capacity charges, TT2PP has capacity charges. And so capacity charge or capital recovery is not new. But even more importantly, after President Mahama left office, the MPP government, the current MPP government, has signed PPAs that has take or pay or capacity charges embedded in them. You'll recall that President Mahama brought in the AXA plant, which is a 370 megawatt plant. We signed it for 5 years. That was during emergency. Immediately the contract expired around June, July. 2 months after, this current MPP administration signed a new contract for the same plant, extending the years from 5 years to 15 good years.
Right. So you have been listening to the Atachia, you've been listening to John Jinapo and Kwabena Donko speaking on this subject, which has been giving a lot of prominence because the chairperson for the Mines and Energy Committee of Parliament, Samuel Atachia, did a press conference, led a press conference, and accused the former president or his administration, John Mohammed's administration, of causing financial loss to the state, according to what the media has reported. According to him, the take-or-pay power purchasing agreements, PPA, signed by the erstwhile Mohammed administration are tantamount to causing financial loss to the state. And he said, quote, "We wish to state that there is no inferred PPA to Asogli, neither has the car power PPA been extended to a regular PPA of 20 to 25 years. Negotiations for these PPAs are still underway. There is a huge financial overhang because of take-or-pay. Take-or-pay is an inherited trouble, no dispute about it. It is not the making of President Akufo-Addo, and Akufo-Addo, kept the lights on." So these are some of the things that Mr. Asachia has been saying, and you remember that the World Bank country director, Pierre Laporte, gave an interview to Joy News, George Weafe, and on the back of that, all of these things are coming up because he stated very clearly that the take-or-pay agreements have cost us a lot. Now, as we understand, over the period, there have been a total of about $368 million. A total of $368 million has been paid for the idle capacities, and there's a further $600 million that has been paid for the cost of reserve margins. So we are talking about a total of $968 million. That's almost $1 billion that has been paid or spent by the state for what is being said is not needed. Joining me, Dr. Theo Champong is economist and political risk analyst. Edward Bauer is MP, Bongo, and member Mines and Energy Committees of Parliament. Let's begin with you, Honorable Atachia. What was the point of this press conference that you held? Ghanaians are concerned that those who have this agreement with us are owed. They've not been paid, and there's a threat that may plunge us into doom. So that's what they are thinking about, and they just want to be assured by the government that this will not happen. So what's the point of your accusations at the former government?
Well, I do not believe that it is my fancy to be doing press conferences. But when you can see that somebody who is in a very, very, very trust-defined situation will want to spew the facts as if nothing is happening, and that maybe this take-or-pay and the consequential pernicious financial effect on the economy is like a mirage, or it is propaganda, at least much to be desired. And that is why I was of the view that let's converge on truth. Because I keep telling, those people who I'm around with, that I do not believe that energy will wear party colors. I told people that as oxygen is necessary for the body, so energy is essential for any economy. And therefore, when it comes to some critical issues like energy, we shouldn't play propaganda with it. Now, I am of the view that what the country director said, the counterfactuals have not been brought. You don't see it. And if you pay regard to the fact that, somebody is trying to get into our politics, what about what some other think tanks have done? I have in my hand what IEA Ghana, working together with Energy for Growth Hub, which is of Washington, D.C. This is what they came out with. And some say, let me show you that some of these facts have not been contradicted by anybody. And if you pay regard to page 3 of the report. They said something like, this was a case of the Ameri deal, for example, a 250 MW combined cycle gas plant approved at a staggering cost of 510 million, or roughly twice the price of comparable projects. In 2018, excess generation capacity contracted under take or pay PPAs cost the government 320 million in capacity charges, estimated to increase to 620 million annually with the addition of new plants in 2019. These unused supply charges are one of the most significant sources of financial strain on the sector. Cumulative net sector debt was 2.7 billion in 2018, with 30% payable to the private sector. This sum is equivalent to 33% of the government's 2018 tax revenue, highlighting the scale of the financial burden. I've not received any data contradicting these, non-political think tanks coming out with raw data. So this is the truth of the matter. And I'm saying that if you pay regard to what the ministry has just brought out, and you look at it critically, the ministry was commenting on excess capacity charge payments. And I want to quote, on the issue of idle capacity, between 2017 and 2020, the annual cost of idle capacity ranged between 105.4 million US dollars and 3.73.7 million per year. Over the period, the total amount of 368 million has been paid for idle capacities, and a further 600 million has been paid for the cost of reserve margins, totaling 968 million United States dollars. We are edging towards 1 billion. Are these inventions? I don't want to do politics at all. Or these are the consequences of the contractual arrangements called take or pay, that in the ambulance situation, NDC found itself, they decided to go into these contracts. And I keep telling...
You have been asked the question, for example, that you have said that, there were 43 take or pay power purchase agreements that resulted in the current government being obligated to pay the amounts that you speak about, $320 million in 2018 for unused power charges. You have been told that this is palpably false because from the Energy Commission's 2018 energy statistics there were only 13 thermal plants that operated in 2018, with only 3 signed under President Mahama. So not 43 plants.
Yes, Samson, I think the video is there. I was just telling you that I was quoting from the IEA Ghana and then the Energy for Growth Hub document. And this is what they said, and I was even quoting it. I was not surmising. During the 2011-2016 power crisis, ECG committed to 43 PPAs, whilst the Minister of Energy signed 3 additional PPAs with EPPs. So that's what I said. And then it went on to say that when MPP assumed power, they terminated, or they terminated 11 of them. That's what I said. I never said at the relevant time the PPAs were 43, and that is why we had excess capacity.
Yeah. So the main question now is, what is the point of your press statements or your press, commentary? What is the point? People need assurance that they will not be doomed, so we will not get there. In any case, this government has been in charge of affairs for upwards of how many years? 6 years or more. So what's the complaint about?
The complaint is that we should sanitize the energy environment. So therefore, if the World Bank director is trying to explain some of the crises we are going through, nobody should say that this is propaganda and that he's descending into the arena of conflict. He should mind his own business. These are facts. So the purpose of my press conference was to set the record straight. That look, if anybody said we have not suffered financial losses or we've not spent colossal sums of money as a result of capacity charges, which were the inherited troubles of Akufo-Addo, then he's living in cuckoo's land. He's living in oblivion. And that is why I'm saying that I am not here to make Akufo-Addo look good. But the fact of the matter is that capacity charges has really brought about financial crisis to this government.
All right.
There's no dispute about it.
So hold on briefly for me. Edward Bauer, what's your reaction to these statements? Of course, the revelations making Ghanaians really, wonder what it is that you were doing during your regime, that you could saddle the country with so much, debt. And in this case, we are talking about power that we don't need, unused capacities.
Yeah, thank you very much, Samson. And then good morning to my senior and my chairman, Honorable Atachia. I will start my discussion by first indicating, because you say that his premise for the statements is made is based on documents that he referred to. One of them being authored by IEA. Indeed, if you go, I have had the opportunity of reading that 10-page document that was authored by Ishmael Aka, who's now the PRC Executive Director, and then one Todd Moses. Go back and look at the sources from which they quoted those figures. All those sources, go back and just look at the footnotes. You realize that the footnotes, the source is coming from newspapers and pronouncements by political operators. So, for example, whether the Minister of Energy or maybe somebody from the government who has made that, it is not from independent sources that they use. And indeed, if you look at that document, in their summary, they indicated that because of the non-transparent manner of the PPAs, they are unable to ascertain those facts. And I think that Honorable Atachia has that document, he can read it, because I have seen that document. I've read it before, it's not today, but at least I've read that document before. That being said, I believe that the centrality of this discussion is one, the fact that the energy sector has some colossal source in terms of debt, where saddled with huge debt, that can result in we going back into power curtailment or power rationing. I believe that is the essence of this. And in that discussion, one of the portions of the source of debt is the excess capacity. And that because of the excess capacity payments, we are forced to be saddled with this particular debt. Something, let me first start with the issue of the excess capacity thing. There's always this, and first, let me also state very clearly, just because I may not have time to say that it is important that today that Honorable Atachia is on live TV with me, that together we will agree on a bipartisan format to call for an independent audit on what the excess capacity payments have been as Parliament, because it is within the jurisdiction of Parliament to do that. That being said, look, something, you always hear the argument that is being made that seems to suggest that, look, we have an installed capacity of about 5,200, and that we have a dependable capacity of about 4,700. And meanwhile, our total needs that we need in terms of peak, if you look at our peak demand, the period in a day where we need the largest amount of power, is around 3,500. And so if you net off, you have a huge figure that is there, that's roughly almost around 1,500, almost 2,000. That is idle capacity, or what you call excess capacity. First, this is a false. One, the fact that the plate capacity on any generating plants is stated doesn't mean that you will have it. For example, your car that you use, you may see that they say it is 200 kilometers per hour. But most often than not, when you are driving, you may not hit the 200 kilometers per hour. Sometimes even in the night, the car performs better than when it's during the day. So you will then have, within that particular installed capacity of 200, maybe your dependable may be 160, maybe your dependable may be 180. That being said, you also then have a situation where whether the dependable is available to you, and we need to use the data that has been made available to us as a basis to do that. As I speak to you, anytime they say excess capacity, the excess capacity is occasioned when, for example, I, as an independent power producer, I have a PPA with an off-taker ECG. ECG, the agreement is that on daily basis, I should provide you with 100 megawatts of power. However, the conditions are this, that me as the producer, me as the person who is producing the power, I must declare availability. And that me, the off-taker, if I'm unable to pick up that power, then I must at least pay the capacity charge. Because remember that when the producer produces power, there are two sources of charges they give. They give what we call the capacity charge. That is for investment returns. And they give you the energy charge, which is the power they have generated based on other factors. So the arrangement is that if I am giving you that, assuming it is a take or pay arrangement, if I say I have declared availability, and you are unable to offtake, then you do that payment. So it means that the fact that you have take or pay does not necessarily mean that you pay excess capacity. That being said, we have consistently stated, yes, that the NDC government coming into power at a time when we had deficiency in terms of generation capacity, and therefore there was a need to add that. And something you recall that in 2006, we had power crisis. And the power crisis, the analysis of it was because for over 6 to 7 years after the last commissioning of a thermal plant, that was in 2000, that was the Tico plant, we never invested in generation. And so by 2006, we had run out of generation, and therefore demand had outstripped supply. On the strength of that, we went into power crisis. So we had this at the back of our mind, that in 2009, when the Mills government came, already there was an agreement that had been made between government of Ghana and Asogli on a take or pay basis. And I want to tell Honorable Atachia, I'm not too sure exactly where you have that information. Go back and check the documents. On the 18th of April, 2007, the power purchase agreement that was signed between Asogli and the then Prof government was a take or pay basis. It was on that basis. You should go back and look at the documents again. So it was after that. So when the 2009, when the government then came, as part of the analysis, government said, look, we needed to rapidly increase our generation capacity. The government had two-pronged ideas on that. One, let's provide power to ensure that we have sufficient for domestic use. And then two, let's also provide power to take care of the sub-region because it then brings in foreign exchange. Indeed, if you ask Honorable Atachia, he will indicate to you that if you look at VRA's books now, what makes VRA's accounts look nice is because of their foreign exports of power. So this was the idea that the government made. Fast forward, we come to a situation in 2017 where the current government says that because of the coming on stream of this power, one of the challenges we had excess capacity. So we then asked, from 2017 that you came into power to 2000 then that was in 2021 that we asked that to 2020. Tell us how much you have paid for excess capacity. The finance minister came and told us that we had paid $937 million for a number of IPPs in terms of excess capacity. Then we got another response that came from the vice president that talked about 17.3 billion Ghana cedis as being payment for excess capacity. The truth finally came out, and this is where something, because we're talking about our indebtedness, the truth finally came out when the finance minister was censured in Parliament, and he then brought us the breakdown of the 17.31 Ghana cedis in terms of payment. One, this is what the finance minister said. He said that between 2017 and 2020, in terms of out of the 17.31 billion that was paid, shortfall in capacity payments was 10.1 billion. What does that mean? Shortfall in capacity payments. You will know that to have a cost-reflective tariff, that means you have a tariff that takes care of all the costs that you have put in that. You must ensure that your tariff is made in such a way that it takes care of all those particular expenditure that is put in to generate the power. In 2017, because government, as part of their political propaganda, decided that they were going to reduce tariffs, they reduced tariffs of around 17%, if you recall. And then even at that time, GIFCO had indicated that an annual loss of revenue was going to be around 231. So I am just giving you a clear indication that because of that thing, the tariff was not cost reflective. And therefore, government had to find money to make up for that gap. And that is the shortfall in capacity payment, which was 10.1 billion. Then the second particular payment was the fuel supply payment, which was 7.31 billion. And Samson, go back and look at the tariff structure that is given by PURC. You and I pay for fuel, and so fuel is a pass-through item. So as long as I put on my power, and as long as I pay my tariffs to ECJ as part of the end user tariff, I am by extension paying for the fuel. So the 7.31 billion that government paid as part of the IPP payments was for fuel, and fuel I and you, we have paid for it. Then the third one was the excess capacity, which is supposed to be 4.99 billion. So out of the 17.31 billion, only 4.99 billion was what was paid for excess capacity according to the Minister of Finance from 2017 to 2020. Something, I now want to tell you something. If you look at, and Honorable Atacha is aware of it, if you look at between 2001 and as today we speak, I tell you that to a very large extent, we have actually not gotten to a state where we'll have to pay excess capacity. And this is the reason.
Okay.
If you look from 2001, and these are data given to the committee, 2001 to 2003, as we speak now, we have not had a situation where our available capacity has gone up to 3,700. We have not had a situation.
Okay.
Indeed. Oh, no, excuse me. No, just to make just one point, end up on one point. So if you have a situation where your available capacity is not up to 3,700 and your peak demand is around 3,480, that's your peak demand. Taking into consideration that you also need redundancy in your system. What it simply means is that we have not had the occasion to pay capacity charges. But remember, I define excess capacity as when the generator declares availability and you, the off-taker, cannot take. And we have not had a situation where a generator has declared availability and then the off-taker has not been able to
Interesting.
take. So that is why we think that there's no transparency in the whole idea of the capacity charges argument.
Okay.
And until we are transparent about it, we'll have challenges.
Right. Dr. Thio Champong, assuming, as we would often do in this republic, that Atacha may have a political twist, to the facts. What about the World Bank country director? Whose report should we believe?
Yeah, good morning. Pleasure to be here. Look, both the NDC and the NPP have twisted this issue to serve whatever agenda that they're trying to push. The fact is, as we sit here currently, the IPPs are owed in excess of $1.5 billion plus, and this is counting, right?
That's right.
To the point that they are threatening shutting off the power supply, and to the point that even the government had attempted to even renegotiate the whole IPP debt as part of the debt restructuring exercise, right? If you look at the IMF report that they issued, they talk about two things, which is kind of driving or part of the debt issues there. That you've got shortfalls in payments, and then you also have arrears that are being accumulated. And so over time, you've got a big amount of money that you need to deal with. So the question really then is, if the IPPs are threatening that they would cut off the power supply, then what is the real reason that we are in this first place at all? The root causes, right? And again, I'll take you or refer you to the IMF report that they issued a few weeks ago. They talk about the fiscal costs that the SOEs are imposing on the economy, and they particularly highlight ECG and then Cocoa Board. In the specific instance of the energy sector and this 1.5 billion that we're talking about, there are three key things that is really driving the issue, which we need to address. Some of them Atachia and then Edward talk about, but others, they're not really, extensive on it. The first point is that currently the tariffs that we are paying or people are paying is not cost reflective, and Edward made that point. So since 2018, when we did the last major tariff review, it took almost 2.5 years. There was no review. And if you recall, even during the COVID time, tariffs did not even go up at all. But at the same time, you have your CD doing whatever it's been doing in terms of the depreciation. You've got issues with the cost of fuel that you need to import. And so if what you're producing and selling, you're not able to recover enough of that, then you're going to end up in a problem where you may have to then cover that shortfall. So that's the first key point. The second key point that we need to again have our minds to is the distribution losses in the sector itself, where almost a quarter, about 26% of the power that ECG procures is unaccounted for. And you need to again have a mechanism of recovering this in the pricing architecture. Then there's a third point, which is to do with excess capacity / let's talk it, take or pay, right? So of these 3 points that I've highlighted, the fact that the tariffs are not cost reflective, number 2, the fact that you've got distribution losses, and the fact that you've got excess capacity payment. In the current context of the 1.5 billion debt that needs to be dealt with by the IPPs, the first 2 factors are even more pertinent. The tariffs not being cost reflective and the fact that you've got distribution losses. The capacity charge issues, yes, it's important, but in the grand scheme of the 3 things here, it is not really the most important issue. And again, let me take you back to the IMF document again to support this. On pages 67 to 68 of the report that the IMF issues, they actually list a number of reforms that the government needs to do as part of the whole conditionalities for the program. And in the energy sector, they actually list 15 specific reforms that need to be undertaken. Of these 15 reforms, only 3 of them directly address the issue of IPPs and PPAs. So in other words, 12 of them are to do with what I've just highlighted, your tariff setting mechanism, the fact that you've got losses in the sector, and all of these are adding up to the arrears to the point that the IPPs are threatening to shut down their operations. And if you look at the capacity payments, right, specific, so just highlighting that third point, there's a document that the PURC is actually published on their website. And it shows you, it's called the PPA register, so the Power Purchase Agreement register. And in that document, they list all of the existing PPAs that we've signed. And then they also show you when it was signed, the capacity, the conditions, and then there's a column there that talks about which ones are take or pay and which ones are take and pay in that regard. Of the 14 existing IPPs, that are currently in operation in the sector, 7 of them are take or pay, and then another 7 are take and pay. But this is where it gets interesting. If you isolate the take or pay ones, and this is the document, so just for the purposes of our listeners, you can actually go on the PPA website and check this right now. All of the take or pay right agreements that exist currently were actually signed during the NDC administration. So I can highlight, for example, Senate, I can highlight Car Power, I can highlight AXA, Amandi, and then Early Power. In the beginning, for Sunon Asogli, which Edward talks about, initially, when this was signed on the 18th of April 2007, that was a take or pay initially, but subsequently being converted or implemented as a take and pay. So as we speak currently, the contracts that we have that have got these take or pay clauses in them, these 7 that I have just talked about, all of them were signed between the period of 2013 to 2016, which is under the NDC administration. So I think we need some candor in all of this, that yes, we've got issues. There were issues with the contracts that were signed and all of that. But the most important thing is that the current cause of the mess that we have in the sector, where the IPPs are threatening to shut down, electricity, is because of the fact that the tariffs have not been cost reflective, and that you also have major distribution losses there. That is the real issue.
So an expert like you, from where you sit, how do you take the assurance from political leadership that we have 1.5 billion to pay, but be assured that we won't go into doom so? How do you take that assurance in a minute?
The solution is quite obvious in terms of what we've got to do. The first thing that the IMF actually has asked the government to do is that by the end of this June, they've got to come up with a plan. It's called the Energy Sector Recovery Plan. We actually had a similar plan in 2019, which at that time we said we're going to deal with all these excess capacity and things like that. The plan wasn't fully implemented, to the point that, again, during the pandemic, like I said, tariffs were not raised and all of those issues. Right. So the solution really is in this updated energy sector recovery plan. And within that, the 15 specific reforms that the government has got to implement. And for me, I think what gives me a bit of an assurance is the fact that these are specific conditionalities that have been more or less imposed on the government. So, for example...
So the tariffs will go up?
Tariffs have to go up. They've already gone up since last year. In August, they went up, was it 27%? Just last quarter, they've gone up another 18 or so %. And will have to go up until such a time that your CD is stable, until such a time that the crude oil prices or the gas prices are relatively stable, and all the factors that drive the tariff up. But quickly, Samson, on the specifics, what they've got to do. We've got to expedite, and this is from the IMF document, we need to expedite some of the renegotiations of the PPAs in terms of reducing these take-or-pay liabilities. That's one thing. We've got to adjust the tariffs. We talked about. We've got to address the issue of ECG and their operational performance. There's the issue of subsidies and also how we actually collect, right, the electricity that is sold and never, collected by ECG. So things like the prepaid meters and things like that. There's a very clear plan on what to do. The specifics the government has got to submit by the end of this June as part of the program conditionalities. That's the only way forward in terms of this engagement. But like I said, the whole take-or-pay thing is just one small subset of a bigger set of problems in the sector. And the most pressing issue really is to do with the tariffs and the distribution losses
Okay. I'm sorry, but I can only give you just 30 seconds of some closing remarks. The Honorable Atachia and also Edward Bauer, please. Start with Atachia.
Honorable Bauer's posture now is very clear. It's very self-defeating. And there's nowhere in the world that if you should bedevil a government with 7 take-or-pay power plants, it will not have cost implications. So I'm glad the solution will come, but let's concede the fact that the take-or-pay, even if it's 7, has serious financial implications for the state. That's all I want to say.
Thank you very much. Yes, Bauer.
Okay. I think that first and foremost, I agree with Doc when he indicates that, look, the power losses within the system is a very serious problem. But if you look from 2017 to 2022, from ECG's own documents presented to Parliament, the total indebtedness as a result of system losses is almost about 13 billion. So that's a huge sum of money. That's the first point. The second point that I need to do is that, look, not only do we have to look at the tariffs to make it to be cost reflective, the whole tariff structure, the guidelines, have to be looked again. Because I do not understand why, for one reason or the other, you know that for a system like the power system, you need to build in redundancies, and you don't key that into the tariff structure. Because it has to be in the tariff structure to be able to, because that becomes a liability, and someone has to take care of it. So that is another thing. And the last but not the least, as I speak to you now, the issue of excess capacity, as we speak now, the government's own document, the Energy Sector Recovery Plan that Doc talked about, have indicated that by 2027, we must add new plants. If that is the case, each plant takes roughly about 24 to 36 months. What it simply means is that as we speak now, in the next year or two, we will not be talking of excess capacity. We will have to be contemplating on how to put in more capacity.
Thank you.
These are the 3 points I need to
Thank you very much. And my guests have been Edward Bauer, MP Bongo, and member Mines and Energy Committee of Parliament. Samuel Atachia is MP Ebuakwa South constituency and chairman Mines and Energy Committee of Parliament. Dr. Theo Echampong is economist and political risk analyst. Earlier, I had Dr. Rashid Pelpuo, MP for Wa Central, and also we had Kwame Jan, who is senior lecturer at the University of Ghana, consultant to the Lands and Natural Resources Ministry as far as land matters are concerned. We also had Bobby Banson, who is a private legal practitioner. My outfit, as always, is by Habil's Couture. You can find Habil's Couture at Ajiringano Gate, East Legon. You can call them on 0200 84 1988, 0200 84 1988. And they want us to let you know that they are having a special Father's Day promotion throughout the month of June. And you're going to get 10% discount on all kaftans. 10% discount on all kaftans. You can also reach out to them on 0200 84 1988. 0200 84 1988. They are doing a Father's Day promotion through the month of June. You get 10% off your kaftans. They have the very best of kaftans for you. I'm Samson Ladia Yanini. Many thanks to my production team and to our guest as well. Have a good afternoon. We'll come your way next week with another edition of Newsfile.
Joy 99.7 FM.